Mediation took less than half the time to resolve problems that litigation took. It cost less than half as much. It was generally perceived to produce results that were more likely to be in the interests of the client. Looking at it just from those basic ideas, it's faster, it's cheaper, and it's widely seen as being more effective. Reality for the vast majority of people is that when your relationship ends, you're mad, you're pissed off, and you're not particularly well disposed towards your ex. That's just the human nature. A lot of people have ideas that, I'm going to go in front of that judge. That judge is going to listen to how awful my ex is, and my ex is going to find out just how bad they really are. Right. And so court for a lot of people is about ideas that are awful, like vengeance and vindication and victory. The problem is that when you're focused on getting revenge about the awful things your ex did, you lose sight of a lot of really important values. Like, it's so much cheaper not to hire lawyers and go to court, but to talk to your ex about how are we going to divide up the family home? How are we going to manage dividing our cat's time between our households? There's actually a sizable body of social science research that looks at family breakdown, family restructuring, and how family law disputes are resolved. Among the many things that we know from that research is that when people who have separated are able to make an agreement resolving their legal differences for themselves, that resolution generally tends to be more durable and longer lasting than the resolutions that you get from judges and arbitrators. And it also shows people who have separated that despite the acrimony arising from their separation, they are able to negotiate and reach compromise and resolve difficult issues about parenting on their own. The research that was conducted by the Canadian Research Institute for Law and the Family, whether we were talking about low conflict disputes or high conflict disputes, litigation took, on average, twice as long as every other dispute resolution process. When we asked the lawyers that responded to our survey, how much do processes cost? Litigation cost more than twice as much as mediation and more than twice as much as collaborative processes. These are astonishing numbers. But when we got down to the really, really important things that have to do with questions about, to what extent are your clients satisfied with that process? To what extent are the results you achieve through that process in your client's interest or in the interest of your client's children? The results provided by litigation were minuscule compared to the level of satisfaction reported by lawyers doing every other kind of process. In general, there are only a few ways of resolving differences of opinion, whether it's a legal difference with you and your ex, or a difference that you're having with your boss at work, or a complaint that you've got with your neighbor about where the fence is built and on whose side of the property line the fence is located, right? You can talk to each other, and that's called negotiation. You can talk to each other with the help of someone else, and that's called mediation, right? When you go to court because you can't agree on this, or maybe you're just not even interested in having the conversation to begin with, and you sue someone, that's called litigation. Collaborative settlement processes are negotiation on steroids. The idea with negotiation is that you're talking to the person with whom you have the dispute. And, let's say that you're selling me your car and you're asking $5,000 for your Ford Pinto. And I tell you that your Pinto is not worth $5,000, but I'll give you $3,000. You say $3,000, that's not enough. Tell you what, $3,500. I say deal. That's negotiation, right? And the same thing applies whether you and I have had a child together and we can't agree about what school they'll go to or how their parenting time should be split up. It's the same thing, right? In collaborative negotiation, what winds up happening there is that you hire a specially trained lawyer and I hire the same kind of lawyer, different lawyer, obviously, but it's also somebody who's had that same basic training. And then together, the lawyers work with us as a team to make sure that each of us has the information each of us needs from the other, such as things like information about employment, including salaries and bonuses, T4 slips, income tax returns, and we will have a series of meetings, me and my lawyer with you and your lawyer, face to face, talking about these issues and trying to work out a solution to our problems without going to court. And what's really neat about collaborative processes is that it's not limited to you, me, and our lawyers. If we have a problem that we can't figure out, like a question about parenting arrangements, or we have a difference of opinion about, say, for example, the extent to which our daughter's special needs are impacting the parenting schedule, we can have a psychologist or a clinical counselor come in and talk to us about the kind of arrangements that might be in her best interest. So when we can involve these expert third parties to help us figure out really difficult problems, all in a way that's cooperative and aimed at finding a settlement that we all agree with. In mediation, generally you don't have all of those other people, right? You've got one person who sort of sits in the middle. They're neutral, and their job is to help us talk to each other, identify underlying interests, and help identify options for compromise. Mediation is a kind of negotiation that's facilitated by this sort of person who sits in the middle. There are, a few circumstances in which I think you need to exercise the decision to avoid court with maybe a little bit of caution. The most obvious circumstance is in cases where there has been a history of family violence. Because in cases like that, there are times when you just need the protections that the court can sometimes offer, because it's only the courts that are able to make orders that only one person have the right to live at the family home and that the other person has to leave. It's only the court that has the right to make protection orders that restrict how, if, and when the parties can have contact with each other. And so when there are issues about family violence, it's not the case that the other processes can't be tried, because mediation can work with specially trained mediators who are expert in dealing with cases of family violence. But, family violence is without a doubt the kind of circumstance that might encourage you to try court as a first step rather than a last resort. The reasons why I would suggest that people try mediation before making the decision to go to court are, firstly, that it is probably better for you and your ex to make your own decision about how your family problems are going to be resolved. Not only does the research tend to show that agreements that people make for themselves tend to be longer lasting than decisions made by judges, but it's helping set the tone for the remainder of the relationship that you're going to have with each other. If you know that you can solve even difficult problems just by talking to each other, having the courage to engage in that difficult, vulnerable conversation and find compromise, this is going to suit you, not just for the mediation, but every time there's a problem coming up in the future. The other problem, when you go to a judge to ask the judge to make a decision for you, you've given up all the power you have to influence the outcome, right? When you're in mediation, the power belongs to you. It's up to you and to your ex to come up with a solution with which you both agree. When you're off to court, you give the power up to a stranger, somebody who doesn't know you from a hole in the ground, doesn't know your kids, right? The other beautiful thing about mediation is that because it's cooperative and not adversarial, which is what court is like, you can have difficult discussions about difficult problems without some of the finger pointing that you tend to see in court.